Good evening, everyone. We're going to call to order the Public Safety Committee meeting. I am Committee Chairperson Suzette Grisham. This matter is a hearing being held before the Public Safety Committee of the Common Council of the City of West Allis. This license hearing is being held pursuant Section 125.12 of the Wisconsin statutes in the matter of the complaint against Amy Thompson, sole proprietor, doing business as Buggin' Out Lounge. Let it be noted for the record that the following committee members are present. Alderwoman Reinke. Please say here. Each button, say here.
Alderman Rose Lee Reinke from the 5th District.
Alderman Turner.
Alderman Ray Turner, District 1.
Alderman Stefanski.
Alderman Tracy Stefanski, District 2.
Alderman Rote.
Alderman Dan Rote, District 4.
Assistant City Attorney Nicholas Serwin is the complainant and the one prosecuting this matter. Assistant City Attorney Rebecca Monti is here acting as advisor to the committee. For the record, we will now have everyone, we stated our appearances. I apologize, I'm going to go back here. For the record, we will now have everyone state their appearances, and that would be the prosecutor and the defense team.
Sure. I'm Nick Serwin. I'm with the City Attorney's Office. I'm representing the complainant. I am not myself the complainant, just to be clear. The complainant is essentially the West Allis Police Department.
Thank you for the correction.
Madam Chair, Attorney Michael Maselman and Attorney Vince Bobbitt on behalf of Amy Thompson, sole proprietor of Buggin' Out, and Ms. Thompson appears at the table with us too. Good afternoon.
Good afternoon.
Good afternoon.
Ms. Thompson, the nature of this hearing is for the committee to make a decision as it relates to the complaint against you, which has been filed with this committee. Under the provisions of Section 125.12 of the Wisconsin statutes and Section 902.20 of the West Allis Revised Municipal Code, this hearing has been convened for the purpose of determining whether any of the charges are true, charges against you are true, and to make a recommendation based on that determination. This committee will examine all the evidence concerning the charges through inquiry to both sides. The committee will evaluate and then impartially weigh the evidence. It will determine whether or not any of the charges have been proven solely upon the evidence introduced at this hearing. This hearing is open to the public. A verbatim record of the proceedings is being made by audio recording. Pardon me?
The video recording.
The video recording, my apologies. And also we do have our clerk present. You are represented by Attorneys Bobbitt and Maselman. Assistant City Attorney Nicholas Serwin is here as the representative of the complainant, which is the West Allis Police Department, and what will represent the case against you to the committee as the prosecutor. Assistant City Attorney Rebecca Monti is also present and will serve as legal advisor to the council. This means she will advise the committee on questions of law and procedure and may also direct questions to the witnesses on behalf of the committee. You may present evidence, call and examine your own witnesses, and cross-examine any witnesses against you. All witnesses will be sworn in and placed under oath prior to their testimony. Both the complainant and licensee shall be limited to 1 hour for each presentation of testimony, not including cross-examination or questions from the committee or city attorney representing the committee. However, the committee chair may extend the time for presentation of testimony as needed to assure a full and fair hearing. Subject to a motion for consideration by the full committee made by a member of the committee, the chair has final ability to rule upon all questions, objections, and motions as to procedural matters, admissibility of evidence, and similar issues. All objections, questions, and motions should be directed to the committee chair. You may testify under oath on your behalf with regard to the charges against you. However, what you say will be considered as evidence. Further, if you do testify, you may be cross-examined by the complainant, the representative of the complainant, and committee members or the committee attorney. If a charge or charges against you are proven, you are advised that the committee may recommend to the Common Council that your licenses be suspended, revoked, or not renewed. The Common Council may accept or reject such recommendation, and the Common Council will make the final determination whether your license should be suspended, revoked, or not renewed. This determination by a common council can include increasing, reducing, or otherwise amending the committee's recommended action if the common council sees fit to do so. You have been served with a summons for the hearing and a copy of the complaint against you, which you have been filed with the committee for determination. I now request the clerk to append as exhibits to the record a copy of the summons and complaint together with a copy of the affidavit of service, which I believe has already been received. Ms. Thompson, at this point, we would normally ask whether you're going to admit any of the allegations or portions of the complaint. However, your counsel, attorneys Bobbitt and Maselman, have submitted a proposed resolution for the complaint. Before asking you to admit anything, and prior to hearing any of the evidence, the committee will consider the proposed resolution. At this time, I would like to give the opportunity to the prosecutor and defense to state your position on the proposal, and then we can decide whether we'll go in closed session to deliberate.
So, I'm going to speak in favor of this proposed stipulation, and I'm not a signatory to it. It is a proposal from the licensee and the attorneys for the licensee basically agreeing to a certain set of facts or resolution if the committee were to choose to go that route. The reasons I am in favor of this, and I have a few of them, so I'll try to be brief about it, but one, I think it provides a really quick, decisive solution that is final. As the committee knows, if the matter were to go to a hearing, there is the potential for an appeal, and during that appeal, oftentimes courts will allow bars or during the appeal to stay open. And so this suspension for 90 days, or the proposal for the suspension for 90 days, would be quick, decisive, and as immediate as the council wants to make it occur. The 90-day suspension is the maximum amount of suspension that is possible. And so they have agreed to that maximum suspension. Now, the only thing bigger than that is a potential revocation. I think, obviously, the incident is serious. I don't want to... Nothing in my comments can minimize that, but I think when you have an individual that's willing to take responsibility and stipulate to a resolution, I think that creates a benefit to future hearings where the committee is involved. In that, you have this kind of template in place where if somebody wants to take responsibility, there's an option to do that, and it kind of creates that finality in the case. Obviously, it's up to you if this outcome is sufficient, but it is the maximum suspension that you can potentially give. As a prosecutor, I always look for specific and general deterrence. Specific deterrence, I think, is clear here that obviously Bugging Out can't have any incidents like this ever again. But in a general deterrence capacity where other bars are paying attention to what's going on, the committee will act abruptly, quickly to answer for what happened. There will be a significant penalty to those bars. And if any bars that are looking to potentially have these, a party like this, they know that they're going to face significant, swift consequences. So I think that it speaks to that as well. Obviously, I already talked about the appeal issues. And there's one more point, and it's a very minor point, but it's something that would become apparent if we proceed to a hearing. But this is still a very active situation for the community and the West Allis Police Department. And so I bring that up because there are pending criminal matters associated with this, and so intentionally there would be some brevity to my presentation. And so this also, this stipulation would also sidestep that issue of the pending criminal matters that are outstanding and my intent not to get in the way of whatever those pending criminal matters may or may not be. So those are my rationale. That's my rationale for speaking in favor of this stipulation, and I will leave it at that.
Thank you. Do you have any remarks?
Yes, thank you, Chairwoman. I'm Attorney Vincent Bobbitt, and I would ask you to go along with the stipulated settlement. I can tell you, I personally, along with Attorney Mike Maselman, spent a lot of time trying to come up to a resolution that made sense. This incident started with a birthday party. The Bugging Out has a hall where you can have events, and she rented it for somebody to have a birthday party for a 17-year-old. It was chaperoned by people that were on security, but it was not from the bar itself. But I don't necessarily know if that's unusual because it was a birthday party, and it started out with a small group of juveniles, and unbeknownst to the owner, there is a fire door that cannot be locked, but at the time it didn't have an alarm. So apparently somebody that was in the party opened the door for other juveniles to come in there and cause this type of trouble. I will tell you that this is a neighborhood bar, hasn't had any significant problems at all in the city of West Dallas, and now this is thrust upon them, no different than thrust upon anybody that has a business in our community at large. And we just saw and witnessed something that happened in Nashville, where this individual literally blasted the glass out of the doors, went in there, and the police were there in 15 minutes, yet we had those fatalities. In this situation, because I don't want to comment on either because there's criminal repercussions, the victims apparently were part of the problem, not the bar. I'll leave it at that. I will ask you to ratify that. As a big thing also, we have Amy, that's a 6-year bar owner, and there's a tried and true progressive discipline. And what that means is 90 days is quite a bit of time to be closed. A significant financial loss. But what the most important part is after this incident took place, Amy Thompson did remedial measures to make sure it didn't happen again. In fact, when the city of West Dallas asked her to do several things, they already had been done. For example, the fire door that now is alarmed. So if somebody opens it, they're notified right away. And some other things were done. She's here to cooperate with the city of West Dallas, wants to remain in business in the city of West Dallas, and this incident, tragic. And I will tell you, this weighs heavily upon her, and I ask you to go along with our stipulated resolution. Thank you.
Madam Chair, if I may, one more point that I want to make sure is clarified.
Go ahead.
We're here. What was it? The proposal is 90 days, and it was pointed out to all the parties that 90 days is going to run into the period of where the bar would have to apply for renewal. Now, in speaking with council, I think we were always on the same page with this, but 90 days means 90 days. There's no, that renewal period, when they renew it would have to remain closed if the committee decided to go that route. If this stipulation is not followed, if it's breached, if the contract is basically a contract, if it's breached, we would just set this back up and do this thing again. And so I think we're all on the same page, but I just want to confirm that 90 days is 90 days. The renewal has no impact on the timeline for the suspension.
That is accurate. It's 90 days from the time the full council would agree to resolve it with our stipulated agreement.
But, Madam Chair, but we would still go through the renewal process. We'd be back in front of you, but if you granted it our renewal, we'd still shut down for the remaining amount, so a total of 90 days.
Okay, and for clarification, renewal is June, correct? The end of June. The end of June, okay.
And up in July.
That's a big deal. Summertime, it's a big revenue loss. Oh, no.
And if I may, that is a big deal because that closure happens during the busy time of year for bar owners, but she's willing to accept your punishment and not to have this happen again. She wants to stay in business.
Okay. All right, and Attorney Monty has a question as well.
So we had this come up recently in another license matter. I did look into it, and it does look like the establishment has a food license. So we would want to, prior to deliberations, I just want to, I guess, clarify whether it would be the intention that you would continue to serve food but not liquor, or if the business would be entirely closed for those 90 days, if that's the proposal.
I'm glad you brought that up because we did discuss this prior to being called. She would close the entire operation, and that would include food and soda or whatever it may be. She's going to remain closed, period. She doesn't want to have any ill feelings with the police department or you council members. She wants to complain, accept the punishment, and stay in business in West Dallas. So she would close entirely.
All right, thank you. At this time, we would need a motion to go into closed session.
I make a motion to go into closed session.
Okay, is there a second?
Second.
Okay. Let me make sure that I have what I need here. I'm sorry. Right here? Okay. Okay, for agenda items 1 and 2, the committee may convene in closed session pursuant to the provisions of Wisconsin State Statute Sections 1985 1A and G for the purpose of deliberating concerning a case which was subject of a quasi-judicial hearing and conferring with the city attorney, who will render oral or written advice concerning strategy to be adopted with respect to litigation in which the city is or is likely to become involved. This committee may reconvene in open session for completion of closed session to consider the balance of the agenda. And we would do a roll call for that, correct?
Yeah, might as well.
Okay. Alderwoman Ranke?
Aye.
Alderman Turner?
Aye.
Alderman Stefanski?
Aye.
Alderman Rowe?
Aye.
And the chair votes aye. We are in closed session.